It is now my distinct honor to introduce our final closing keynote speaker of the day, Professor Graeme Dinwoodie, who holds the chair in intellectual property at Oxford University in the Department of Law, and who is widely regarded as one of the most distinguished trademark scholars in the world, and who I also count, I must say, as a dear friend for many years. So without further introduction, please welcome Professor Dinwoodie.
Thank you, David, and thank you to you and Russ for the invitation to talk. As I saw the time disappearing, since we're running a little late, I asked Barbara Laurie at the back, who is a fine limerick writer, if she could reduce my entire 45 minutes to 15 seconds. So here goes. And this is, I will not render this as Barbara would, but I gather some MEPs fear that him sounds a bit queer. But others may say, is EU IPA an office or regional beer? So there we are. That shows Lee. Some of you may know Barbara from her SEPA limericks, but that's on 2 minutes' notice. That was very impressive, Barbara. In selecting a topic on which to talk about offering a transatlantic perspective that brings together European and American trademark lawyers, it might seem a trifle odd and maybe even a little perverse to have chosen the question of territoriality. It is perhaps a paradox that when treaty negotiators established the framework of international trademark law in the Paris Convention in 1883, they opted to do so on the basis of the principle of territoriality. But it's a very well-established principle, and one indeed that pervades all of intellectual property law. So I suppose in another sense, it might seem a perfect topic for a transatlantic gathering, in that territoriality is a principle that has common acceptance as the basis of trademark law, both in the United States and in the European Union, as you can see from the of illustrative quotes that I have on the board from both jurisdictions. However, in recent years, global trade and an online marketplace have called into question the practical relevance of the principle that trademark law is territorial. There's a growing gap between the global reach of markets and the national scope of marks. Trade is international, in fact, but trademarks are legally national. And that gap between law and commerce creates costs and uncertainties. And these are not new concerns about the gaps between law and commerce. In fact, the Paris Convention itself in 1883 was a response to pressures on national systems created by international trade. And in fact, every so often, in the 130 years since, litigants or scholars, policymakers or courts will remark on the fact that we are living in a vastly new world and that trademark law must dramatically adapt and get rid of the principle of territoriality. So the question I want to consider is, what, if anything, is trademark law to do now about this apparent gap between commerce, commercial reality, and legal principle? How, if at all, and the if at all is important, should we reconfigure legal principle to comport with commercial reality? Well, 2 months ago, as was mentioned in the last panel, we celebrated the 20th anniversary of the promulgation of the community trademark regulation by the European Union, which might be seen as a quite radical reform of the principle of territoriality, creating the possibility of a unitary right, valid and enforceable through what is now 28 countries, that will be 27 when Scotland is expelled in 6 months' time. The CTM, I should say illegitimately expelled, when the CTM is discussed, it's now discussed very much, in fact, as a model for regional and global replication. And in fact, you can find it serving as the model for proposals in Africa, in Russia, in Australasia, in terms of a New Zealand Australian unitary mark, and even in, and I think this is in some ways the most ambitious, a Lusophone trademark, which would be a unitary mark available in all 7 Portuguese-speaking countries. And if you're not Portuguese, I think you should get a prize if you can name all 7 Portuguese-speaking countries, but that's an interesting sense of the influence of the CTM in structuring a debate about how we get around the problems of territoriality. So what I'm going to do is consider whether the system that's been implemented by the CTM has in fact mitigated the problems of territorial trademark rights, and whether it provides a way for other countries, in fact, to adapt trademark law for global markets. Well, before I lay out the ways in which the CTM has tackled the problem of territoriality and discuss some of what I think are the current challenges that the system faces, I want to briefly make a couple of preliminary observations about the principle of territoriality itself. And I think these will help understand the problems that the EU is grappling with and maybe give us some insight about how we might reconfigure trademark law. Well, first, statements about trademark territoriality, in fact, mask a variety of related but different propositions. Territorial philosophies separately affect rules regarding trademark laws, the acquisition of rights, and the enforcement and scope of rights. So starting with trademark laws, the group of norms that determine the availability and scope of rights, these are still largely territorial, but they are promulgated increasingly because of the level of harmonization with an eye to international norms such as TRIPS. Trademark rights are also acquired on a territorial basis. Territoriality requires a producer to obtain separate rights in each jurisdiction for which it desires protection. In the United States, historically, that meant using in commerce. In most countries outside the United States, that, of course, is achieved by making a separate application to the national offices in which rights were sought. And finally, enforcement mechanisms are territorial, which has a proposition that has a couple of different dimensions to it. So first of all, a British or UK trademark confers rights only within the United Kingdom. Extraterritorial enforcement or relief is an exception that national courts typically only consider in a very limited number of circumstances. And unlike causes of action in private law, such as, say, tort or contract, any trademark infringement typically must be brought in the country, the courts of the country who granted the rights in question. Normally, you cannot sue on the basis of a foreign trademark right. So what's the value of disaggregating the general principle that we take for granted that trademarks are territorial? Well, for one thing, different aspects of territoriality create different problems, and with different problems, they prompt different solutions. So territorial norms, territorial laws, are ameliorated by substantive harmonization, things like TRIPS. Mechanisms like the Madrid system address the costs of formal acquisition of rights. And cross-border enforcement problems that are created by territoriality require jurisdictional reform if they are in fact to be addressed. Moreover, when you separate out the varied aspects of the territoriality principle in trademark law, it becomes apparent that different rules of trademark law possess a territorial character for different reasons. And that, I think, I'm going to suggest, needs to inform how we go about reforming those rules. And I want to illustrate that point by focusing on an American example that the American trademark lawyers here will know very well. That's the United Drug versus Recitals case from 1918, a Supreme Court decision, which is a contest between two geographically remote marks, identical marks, RECs, used for similar products in Massachusetts and in Louisville. And under the normal common law rule in the United States, you would think that, in fact, Regis, which was the predecessor of the plaintiff, United Drug, having been the first to use in the United States, would be the owner of the rights. But in fact, the Supreme Court held that Rectanus, who had adopted the same mark innocently without knowing of the Massachusetts merchant, in fact would have the rights in Louisville. The Massachusetts owner would own the rights in Massachusetts, and the Louisville owner would own the rights in Louisville. Defining the scope of trademark rights in that way, in that territorial way, flows, in fact, however, from the intrinsic purposes of trademark law. Because in Louisville, the Kentucky consumers, when they saw the mark Rex, expected the goods to be coming from Mr. Rectanus, and in fact not from the Massachusetts company. And if you allowed the rights to go to the Massachusetts company, then in fact the consumers in Kentucky would have been deceived. Thus, the area in which the mark was used was the central determinant of the scope of rights, as you would expect, in fact, in a use-based system. And you can see some of the same in passing off cases, for example, in the United Kingdom. In the United States, trademark rights are acquired and dependent upon use. And so under United Drug, the metes and bounds, the definition of the bit of property you get by use of a trademark, are defined both with respect to the products on which you use, but also with respect to the area in which you use. It gives another different dimension along which the metes and bounds are defined. When the United Drug Supreme Court decided that case in 1918, they did, however, issue a caveat, and I have the full paragraph in which the caveat appears on the screen, which is that the adoption of a trademark does not, at least in the absence of some valid legislation enacted for that purpose, project the right of protection in advance of the extension of trade. And with the development of a national economy in the wake of the Second World War, Congress did in 1946, in fact, enact comprehensive legislation for the purposes of projecting the right of protection in advance of the trade, namely the Lanham Act. And you can see that in the language from the Senate report that I have on the screen. In particular, the Lanham Act's more liberal scheme of federal registration was enacted partly because commerce was becoming more national in nature. And the Act sought to facilitate enforcement of rights on a national basis throughout the United States by, among other things, deeming registration of a mark on the principal register to be nationwide constructive notice of the claim to ownership. As a result, if in fact the federal registration had existed in, say, 1877, if there had been registration, then in fact Mr. Rectennis would be deemed to have constructive notice of the first user's mark and would have created national rights for the Massachusetts merchant. All right? So federal registration secures for the registrant nationwide priority, notwithstanding that it might use the mark only in some part of the United States. Now, without getting into all the details of the interaction of common law and registered rights in the United States, the key is that statutory registration schemes overlay common law principles of territoriality. Now, that doesn't mean to suggest that registration schemes and registration systems are not territorial. They're very decidedly territorial. But registration systems reflect, in greater part, the role of trademark law as an instrument of economic and industrial policy. Their territorial character, the territorial character of registration rules, is due more to the reach of the policymaking or administrative authorities than to the intrinsic nature of goodwill or trademarks. The result of that is that registered rights are more likely to conform in scope to the territory of the political authority that issued them. Economic policy and judicial enforcement are largely responsibilities of the nation state, and accordingly, the registration overlay on top of the intrinsic territoriality is national. And likewise, territoriality of trademark laws, trademark acquisition practices, trademark enforcement mechanisms tend to reflect a political notion of prescriptive power, practical concerns about the ability of courts to enforce laws. And these rules actually assume their territorial character because of their connection to the political institutions who promulgate them and who enforce them and who have a territorially defined political sovereignty. In contrast, rights that are defined by area of use or by reputation or by renown are less likely to conform to artificial political boundaries, are instead likely to be more closely congruent with the breadth of social or commercial patterns of interchange. All right, so you may say, well, why does that actually matter? Well, if the territorial character of a rule reflects the intrinsic purposes of trademark law, where do consumers associate something with a particular sign, trademark protection will almost inevitably mutate as the notion of territoriality evolves in line with social and commercial change. If, however, the territoriality of a particular doctrine instead mirrors the national nature of economic or political or judicial institutions, then efforts to revise those doctrines will require altering the underlying institutional and policymaking apparatus. Now, one might object to this analysis by replying that what I am observing is simply the use-based nature of the American system on the one hand, that will inevitably have little relevance when we come to thinking about the problem in the European context. In the United States, a right is created by use and only confirmed by federal registration, whereas in the European Union, a property right is created by registration without use. And in fact, you might say, if I was trying to find a parallel in the United Kingdom to the United Drug cases, I wouldn't look at registered trademark cases, I would look at passing off cases where we regularly think of geographically defined goodwill. But in fact, it is common in both systems, despite their different theoretical starting points, for both conceptions of territoriality based upon the intrinsic nature of goodwill and political sovereignty to inform trademark law. And so although I just illustrated the proposition with respect to the United States, they can be found in current EU trademark law, and that's actually what I am now going to turn to for the rest of my remarks. So even after the harmonization directive ameliorated the problem of different territorial laws so that we essentially have the same laws throughout Europe, rights are territorial, acquisitions is still territorial, and enforcement was territorial. Right? So that is where the trademark regulation comes in. The regulation is actually concerned with something different from the directive. It's concerned about impediments to trade that are precipitated by different national rights, even in a harmonized legal system such as we have in the European Union. That's why we have the CTM. The CTM places great emphasis, as we've heard before, on the unitary character of the registration, which is reflected in Article 1.2 of the provision. So a trademark shall have a unitary character, it shall have equal effect throughout the community, and shall not be registered or be declared invalid, nor shall its use be prohibited, which we'll come back to, save in respect of the whole community. Now, that unitary character is what presents opportunities for substantial cost savings in acquisitions, because, as we know, you can acquire rights for the whole EU with a single application to OHIM, as it now is. Moreover, EU-wide relief via a single infringement action was held out as a possibility to be pursued through so-called CTM courts. And finally, it was thought by some, though this is maybe an interesting debate point, that even use in a single country would be sufficient to maintain a valid EU-wide trademark registration. The important point here is that the introduction of the unitary CTM was reflective of political change from a national to EU level control of industrial policy, rather than changes in the market and culture in Europe. Compare, for example, the language of the US Senate report with the language in the recitals to the CTM regulation in 1994. The tenses are what I want you to focus on. So if you look in the Senate report, the United States went to a federal level because it then had already a single market that was national in scope. Right? Compare that with the recitals in the trademark regulation. I've used the 2009 version. The same recitals appear in the 1994 version. It's aspirational. It's in order to encourage trade to move from the national level to the EU level. It's much more forward-looking. And that, I think, creates a difficulty, particularly in light of the last recital, which is a reflection of the intrinsic function of trademarks, which is to identify source, which has a much more intrinsic, as opposed to political, territorial character. And I want now to turn to some of those challenges. And the first challenge is the case law on the question of distinctiveness. Well, as we know, to secure a CTM, an applicant must show that it passes both the absolute and relative tests throughout the entire European Union. That is to say, a single conflicting mark in any member state will doom the CT application. At one level, this regard for earlier national rights is completely sensible. From the point of view of the intrinsic purposes of trademarks, if consumers in Greece see a mark as indicating a particular source of product, then granting a CTM, notwithstanding that prior Greek mark, would only cause confusion in Greece. By the same token, however, there is a tension created between that sensible proposition with the political and industrial policy of the European Union to forge a unified market and to allow traders to expand the scope of their trade to the entire EU. This approach also means, for example, that if a term is descriptive in a single member state, or more properly, more textually, I should say, in any part of the community, but it functions in many ways as in any member state, then you must be denied registration as a trademark. And this requires consideration of 23 languages, which is apparently now even going to be required at the national level. A descriptiveness rejection can, of course, be overcome, as paragraph 3 suggests, by showing that the mark has acquired distinctiveness, has secondary meaning in American terms. But the courts have held that this secondary meaning has to be established in every part of the EU in which the mark might initially have been descriptive. Thus, in cases where the descriptiveness problem is pervasive, consider product shapes, for example, which effectively have that problem, secondary meaning, effectively use, may have to be shown in all 20 member states. So that's a very, very large hurdle. The courts have actually rejected the argument that instead what you should have to show is acquired distinctiveness in a substantial part of the community, and the cases to that effect are on the screen at the moment. One could argue that this country-by-country approach is required by the basic intrinsic purposes of trademark law. The applicant shouldn't acquire rights in a term that would be descriptive or generic to consumers in one country, even if most of the other EU consumers might actually regard the term as a source identifier. But it clearly is not an approach that is premised on the idea of the EU as a single and fully integrated market. That's basically the picture, and I have to apologize to all Croatians because this is before accession of the last 28 member state. But that's basically the picture of Europe that distinctiveness case law presents. Essentially 27, now 28 different jurisdictions. The Max Planck review that's been referenced in the last panel suggested that this approach should be revisited And there might even be some vague hints of slight backtracking in the case I had on the prior slide in the chocolate bunny case, though it's all really dicta in that particular case. But the recommendation of the Max Planck Institute has not been picked up by the Commission or by the Parliament or Council in pending reforms. There appears on the issue of distinctiveness an unwillingness to view the EU as a single political territory and ask the questions of distinctiveness in terms of European consumers. That is to say, we are still holding in this context to the reality that the European Union is not a single market, but in fact is a one political community comprised of separate markets, in which some of which the mark won't actually function as a mark, and we need to be concerned with that. In other areas, however, the Court of Justice has articulated rules that appear to view the Union as just that, an integrated territory. Even here, however, as I'll come back to in a couple of minutes, the nature of marks as intangible rights with an intrinsic territorial scope apparently continues to inform how courts decide cases. For example, in the EU, marks with a reputation obtain protection against dilution. And if you look at the regulation, Article 9.1c, the relevant provision, it explicitly states that this additional protection will be available to marks with a reputation, and I quote, in the community. Well, as many of you probably know from who are European practitioners, in Pagel versus Tiromilch, the applicant had a reputation in Austria, but nowhere else. The owner wanted relief throughout the entire European Union. It had a CTM, and therefore it claimed we have a reputation in the community and therefore can take advantage of 9.1c. After all, Austria is part of the community. All right? While the Court of Justice held that to be protected against dilution, a CTM must be known by a significant part of the public in a substantial part of the territory of the community. And it accepted, moreover, that in fact Austria could be a substantial part of the community, and sent the question of that back to the Austrian courts. And you can guess what the Austrian courts answered when the question was, is Austria a substantial part of the European community? Taking this holding alone, there appears to be at least an initial inconsistency between the approach taken by the Court of Justice to the territorial aspects of distinctiveness on the one hand and reputation analysis on the other. As the Advocate General Sharpston explained, an approach which focuses on member state boundaries, with a quote there, the approach which focuses on member state boundaries when seeking to establish the extent of a CTM's reputation is fundamentally misconceived. Rather, she said, the starting point must be to consider the territory of the community, regardless of frontiers, as a single and indivisible whole. So here the court appears to have accepted that it should view the EU as a discrete, single, separate market, regardless of actual commercial variation. So that is Eleanor Sharpston's view of Europe, and I haven't asked her to say that she actually endorses that, but I draw that from her opinion in Pagel. Moreover, the Pagel approach of insisting on the community as a whole, essentially erasing the political borders as being the relevant territorial unit as a single territory, regardless of our actual markets, appeared to gain the upper hand when the court handed down its decision in Leno-Merkin involving genuine use. In that case, the court held that the territorial borders of the member states should be disregarded in the assessment of genuine use in the community. The community as a whole was the market against which the sufficiency of the use necessary to maintain the rights had to be assessed. Thus, use in a single state, to get back to what we talked about briefly earlier, might be, in certain cases, sufficient to maintain a CTM, but it wasn't necessarily so. But this apparent trend towards viewing the EU as a discrete market relevant for assessment of the trademark questions, apart from the commercial reality that a mark had been used, for example, in only one small member state, needs to be now considered in light of the DHL decision of the Court of Justice regarding the scope of injunctive relief. Remember, another purported benefit of the CTM was that the owner of the CTM would be able to secure relief throughout the entire European Union in a single proceeding. One of the manifestations of historical territoriality is that enforcement of rights could only be secured from the country that granted the particular right. And the ECJ had frustrated efforts by some national courts to use the Brussels regulation as a way of granting cross-border relief by essentially reading very firmly the exclusive jurisdiction provision in Article 22.4 of the Brussels regulation. Well, the CTM appeared to get around this particular problem of enforcement because the regulation created so-called community trademark courts, CTM courts, sitting throughout the entire European Union. Though in practice, these are merely designated national trademark courts sitting wearing their European hats in the afternoon. And the regulation also created what is termed international jurisdiction, which gave those CTM courts that were exercising jurisdiction by virtue of the domicile of either the plaintiff, claimant, or the defendant, which Anna referenced in her design discussion this morning, it gave those courts the ability to grant European Union-wide relief. And therefore, we seem to have got around that third set of problems of territoriality with respect to enforcement of rights. But the DHL Court case, I think, has tested the limits of that benefit. So the facts of DHL, again, you probably know, but Chronopost owned both French and CTM marks for web shipping, for services involving the collection of delivery mail using the web. I make no further comment on that. DHL used the same word to designate its internet-based express mail management service, which strikes me as an entirely natural use of that word. The French court found infringement of both the French and the CTM registration, but the question arose, and it's hard to see how it arose entirely because the French lower court judgments are a little bit Delphic, but the question arises, which the French Supreme Court refers, as to whether or not the injunction should be European-wide. The court's answer, I think, is very interesting. Basically, the court says that you start with European-wide relief, but there may be circumstances in which you may need to cut back from that European-wide relief. And the basis for that conclusion is a reflection of both the political and the intrinsic territorial aspects of territoriality. So the territorial scope of a prohibition against further infringement is to be determined, on the previous slide, both by the territorial jurisdiction of the CTM court issuing the prohibition, that's the political sovereignty, and by the territorial extent of the CTM mark's exclusive right, which is adversely affected by the infringement. And that is an intrinsic conception of territoriality. That is to say, where the court basically said where the court in question has so-called international jurisdiction, as the court had in DHL, we start with the political assumption of EU-wide relief, but it may, in certain circumstances, be restricted because you only need to grant relief where the functions of the mark, the intrinsic functions of the mark, would be adversely affected. All right? In practical terms, that means that you're going to get an EU injunction, says the court, unless one of two things apply. First of all, if the claimant doesn't assert infringement of its mark outside the territory in question, or secondly, if the infringement has occurred in only a particular group of member states because the existence of confusion is dependent on a specific linguistic use in those territories. So the idea that perhaps because of linguistic difference, some use that would be confusing in France might not be confusing in Germany. Now, the approach that the court has adopted is basically an attempt to reconcile the political territoriality with intrinsic territoriality. The political territoriality says it's a unitary right. The entire area of the EU should be the way we're going to pursue economic industrial policy. And it's trying to reconcile that with the intrinsic territorial marks, which is the consumer association may actually have a geographic scope that is something less than the entire European Union. Now, that result to American lawyers might look a little bit like concurrent use registrations, or at least the philosophy underlying concurrent use registrations, make it look a little bit like the remedial rule that Don Donuts articulated in the 1950s. All right, and may come back to the extent to which it actually is those if I have time, but probably not. So there are clear parallels to what the US went through the second half of the 20th century. What is going on when the court comes up with this particular conclusion? Well, I think it just simply reflects the enduring power in courts, in litigation, of the intrinsic territoriality of marks. The legislative process may have decreed that there is a unitary mark operating in a single market called the European Union. But the courts fully appreciate that this is not always the commercial reality. And I would suggest, as the European Union expands in size and diversity, ironically, this impulse on the part of courts will perhaps become even stronger. More speculatively, I think DHL highlights the limits of imposing a rule of political territoriality without creating the political institutions or adopting new methods appropriate to make that political vision come true. Community trademark courts are actually national judges sitting in their home courts in the same building, wearing their community European hats. They tend to consider the questions of consumer association and consumer confusion the same way they did in the morning as they do in the afternoon. French CTM courts are likely, quite naturally, to view the question of confusion through a French lens, and British courts are likely to do the same, not through the French, through the British in respective terms, all right? If one elevates the intrinsic territoriality of marks, this makes perfect sense. But if the overriding commitment of the European system is to create a single unitary market and to forcibly go there, that is integrated with all 28 countries, the relevant question that the court should be asking in the first place is, in fact, whether a European consumer, not a British or a French or a German consumer, but whether a European consumer would, in fact, be confused. Because the national courts have simply been commandeered in aid of the European project, the EU legislature has not really fully created either the institutional infrastructure and the Court of Justice hasn't mandated the methodological shift that would further the goal to thinking of European trademark law in that way. Now you may say, well, what about the United States? Well, of course, the United States federal judges do also think of themselves as shoppers, but they think of themselves as American shoppers, not Texan shoppers or New York shoppers. In the United States, the political territory and the commercial and social territories are relatively, not entirely, but they are relatively congruent, and certainly a lot more congruent than in the European Union. We have created the legal fiction of a unitary market, whereas in reality the market remains, far more diffuse. Asking the question from the perspective of a European consumer would involve the creation of a fiction, although we already treat the consumer as a fiction in European trademark law for normative reasons, and it wouldn't be that much of a jump to make it a European fictional consumer, as we do at registrability, because we assume at registrability that they speak 23 languages. There probably aren't too many consumers in Europe who speak particularly Irish Gaelic, so the fiction wouldn't be a huge jump. Recognizing the character of these territorially related issues might help to identify the further reforms that are necessary in the EU. If what we're trying to do in the EU is to push and obey the political imperatives of a united Europe, but also recognize the intrinsic appeal and perhaps the intrinsic value of local markets, then I think the European courts are going to have to, consistent with DHL, develop remedial devices that are much more flexible, rather like the devices that American law developed over the second half of the 20th century. And indeed, that recognition was at the heart of at least one of the Max Planck proposals for coexistence of CTMs and local rights. But again, that proposal, which got a lot of grief when it was put out there, hasn't found its way into the draft legislation. And I say that I regret that, notwithstanding that variants of that proposal, variants of coexistence, are already in the CTM system. Right? The compromise necessary to effect the enlargement in 2004 from 15 to 25 countries, that was a compromise that to some extent moderated the unitary nature of the rights. The treatment of rights of mere local significance in Article 8.4, another example where in fact there has been a willingness to recognize that you can have a CTM and you can have local rights, but the Max Planck Institute proposal was shot down, including by most of the trademark bar, I think rather too quickly. If instead what we're trying to do with the CTM is simply move marks in advance of trade to create European-wide trade, then I think the policymakers need to do more to consolidate that political imperative. So, for example, I think they need to create real EU-level courts, perhaps require courts to ask questions in terms of the EU as the relevant single territory, and perhaps with respect to a notional European consumer. So, for example, and I don't want to get into the current British debates about the merits of survey evidence and witness collection exercises, but let me simply suggest that it may require greater reliance on empirical evidence to allow national judges who are moonlighting as CTM courts to don the mantle of the European consumer than it does for them to approximate a national, reasonable, average British consumer. In Europe, the gap between intrinsic commercial territoriality on the one hand and political non-territorial aspirations is still, even now I think, in 2014, too wide to be bridged without more aggressive political change. In the meantime, the national courts are having to grapple with the difficulties created by this tension, and they appear to be adopting a pretty pragmatic approach. So in Interflora and Marks & Spencer's, the trial court had assessed Interflora's claim by reference to reasonably well-informed and reasonably observant Internet users in the United Kingdom, and had made no finding whatsoever with regard to Internet users in other member states. However, likewise, the defendant had brought forward no evidence to show that Internet users in other member states had different characteristics or interpreted Marks and Spencer's ads in a different manner than UK users. And what Mr. Justice Arnold therefore did was he rejected the efforts to restrict the scope of injunctive relief by putting the burden on the defendants, essentially to carve out and prove the local variation there therefore requires a carve-out. So the default is that the British consumer is a European consumer is a British consumer, and we put the burden on the defendant to prove the country. That DHL decision, however, has also brought back into play a question that was left unanswered in Pago, the case involving dilution. In that case, the question arose whether even if there was reputation in Austria that constituted reputation in the community, warranting dilution protection, would the relief that an Austrian CTM court would grant extend beyond Austria? The court didn't answer the question, but Advocate General Sharpson thought that it would not, because there was no need to give any wider order than necessary to further the intrinsic objectives of trademark law. The Max Planck study appeared to support the reading that Advocate General Sharpson had offered, and we now have decisions in the last year from both the German and the Dutch courts that actually apply that rule. The Dutch case, which I think is an interesting one, involves spam. For some reason, someone decided they would use spam to market an energy drink. There we are. This is why I don't do marketing, as it's made. But in any event, Hormel was not particularly pleased with this and sued, claiming that it was infringement of its mark spam for, I think, what they call canned meat products. They sued in the district court in the Hague, and the court rejected the confusion-based claim on the basis that the products were just too dissimilar, canned meat and an energy drink. But of course, that doesn't stop the potential dilution claim. But that failed. Well, applying Pagel, Hormel CTM was entitled to dilution protection if it had a reputation, a substantial part of the community, and one country can potentially, under Pagel, constitute a substantial part. And in fact, it had a substantial reputation, you can guess, in the United Kingdom. However, the Dutch court refused to grant any relief because it didn't have any reputation in the Netherlands, notwithstanding a number of Monty Python sketches that they thought were too old to constitute evidence of the meaning of spam. Because there was no intent of the part of the defendant to use the spam mark in the United Kingdom, and there wasn't any reputation in the Netherlands, the plaintiff, the claimant, was unable to show that there would be any detriment to the distinctiveness or the repute of its mark, and no unfair advantage, because it did not have a reputation in the Netherlands. So in theory, it had unitary dilution protection, but it wasn't able to obtain relief outside the particular place where it had a reputation, namely the United Kingdom. What is to be learned from the European experience for those who might want to depart from a territorial model and mimic what we have done? Well, first, I think there's an irony here, and that is that the reluctance of European courts, whether it be the Hormel court, whether it be the DHL court, to follow the unitary principle, which is clearly the foundation of the CTM system, is in part a function of the growing size and diversity of what is now the European Union. And you see this actually explicitly even in the Leno-Markin opinion. A number of countries pointed it out. In 1957, the possibility of a CTM involving 6 relatively similar countries with a smaller number of languages of similar economic standing, I think would have been regarded as a perfectly rational and not much of a jump beyond the social and commercial patterns of exchange. In a union of 28 countries and 23 languages, reconciling the different intrinsic territorial dimensions to consumer understanding is going to require substantially more flexibility than it would have had if we adopted the CTM or had adopted the CTM in 1957. Despite that, the mild, and I really think mild, it was mild, and I mean this with the greatest respect because I thought it was a great proposal, but the mild proposal that Max Planck made for coexistence of local and federal rights met with very fierce opposition. And likewise, the proposed reform on the treatment of mere local rights hasn't found its way into the proposals. To state the matter a little bit more conceptually, just as there are problems which we all readily get with trademark law lagging too far behind the marketplace, so too there are challenges if trademark law moves too quickly ahead of the commercial market. Despite the rhetoric of a global marketplace or a regional marketplace of 28 countries, linguistic, cultural, and other forces ensure the maintenance of local and regional markets. And that might not be a bad thing if we value the joy of difference even in our integrated community. Indeed, that is to some extent the concern that prompted the endorsement of territoriality as a principle of international intellectual property law in the first place. It was the idea of diversity within unity within an international scheme that actually supported the adoption of the principle. And courts and policymakers in the European Union are now being confronted, I think, with this reality. In the short term, the European courts and legislators will continue to face difficulties, I predict, in reconciling the different demands of the political conception of territoriality with its intrinsic conception. Looking more further afield, for countries who have not yet mimicked the EU experiment, this suggests perhaps harder thinking about more incremental approaches to resolving and modifying the problem of territoriality. In the United States, over the years, judicial interpretation of core concepts of trademark law, such as use, such as distinctiveness, or perhaps more fundamentally, who is a European consumer and what are their characteristics, has managed, without vast disruption of legal principle, to incorporate changing social and commercial practices that affect the territorial reach of consumer understanding. It may be a much more conservative approach, but I think it's an approach that needs to be considered along with the ambitious approach that we adopted here in Europe 20 years ago. Thank you.